I'm Ben Meiselas from the MeidasTouch network. Just one day after it was reported that the federal judge overseeing the grand juries that are investigating Donald Trump for crimes relating to the January 6th insurrection and election interference ruled that Donald Trump's assertion of executive privilege to block the testimony of his former top White House lawyers, Pat Cipollone and Patrick Philbin, was an invalid assertion of executive privilege. We are now seeing Patrick Philbin and Pat Cipollone both entering the grand jury on Friday, ostensibly to testify now that the executive privilege claims by Donald Trump were defeated. This is big, folks, and you will recall that back in September, Pat Cipollone, the former top White House lawyer in the Trump administration, and Pat Philbin, who was Cipollone's top deputy, they testified before the grand jury investigating potential crimes by Donald Trump relating to the insurrection and election interference. They testified back in September before the grand jury. And then thereafter, we learned and we reported that they didn't testify on all matters because they were forced, even though I think they didn't want to assert executive privilege because Donald Trump was claiming executive privilege over anything relating to direct communications with him and anything they heard Donald Trump say. So they were able to testify about other observations that they made, their conversations and communications with others. But similarly, when they were asked these questions before the January 6th committee, when it came to what did Trump specifically say to you or what did you hear him say, they were restrained because Donald Trump was asserting executive privilege. And they said, absent a court order by a federal judge, we can't testify on those matters, even though we'd like to testify and we'd be happy to share it with you. Just go back, get us a court order, and then we'll testify on those issues. Look, a frivolous objection by Donald Trump, but nonetheless, because he is such a destructive maniac, he's able to make at least the assertion, even if it's frivolous. So we learned earlier in the week, on December 1st, that the executive privilege claims had been overruled, that a judge who oversees these grand juries, the presiding judge who oversees all criminal grand juries in Washington, D.C., federal judge Beryl Howell, ruled that Trump's executive privilege claim is without merit, and she ordered Pat Cipollone and Patrick Philbin to testify regarding their direct communications with Donald Trump and what they heard Donald Trump communicate to them or in their presence. And this is really, really big. You'll recall that Pat Cipollone testified about a lot of very important matters before the January 6th committee here. This is a clip before the January 6th committee of Cipollone telling the committee that there was not sufficient evidence of fraud to overturn an election and that Trump should have conceded. Play this clip.
Did you believe, and Mr. Cipollone, that the president should concede once you made a determination based on the investigations that you credited DOJ did? And did you, in your mind, form a belief that the president should concede the election loss at a certain point after the election?
Well, again, I was the White House counsel. Some of those decisions are political. So to the extent that, but if your question is, did I believe he should concede the election at a point in time? Yes, I did.
And here's Pat Cipollone talking about Trump's plan to have the federal government seize voting machines. And Cipollone told the January 6th committee to have federal government seize voting machines. That's a terrible idea for the country. I don't understand why we even have to tell you why that's a bad idea. And so in addition to Cipollone and Philbin testifying, and you saw the photographs of them entering and exiting the federal courthouse on Friday, similar orders overruling or rejecting Trump's executive privilege claims were made by federal judge Beryl Howell with respect to former Vice President Pence's former top deputies and staffers. So Mark Short, who was Vice President Pence, former Vice President Pence's former chief of staff, as well as Greg Jacobs, the former general counsel to former Vice President Pence. A similar process took place there, where back in October, they were compelled to testify as well after they had previously testified earlier in the summer, and they couldn't testify on these specific issues regarding their communications with Trump or what Trump told them or what they heard in Trump's presence from Trump, because they were constrained based on the executive privilege claim. Even though they all view it as frivolous, they have to go through the steps that the law requires, because the law hasn't really been able to grapple with a situation where you literally had a president who was a criminal and engaged in criminal acts every day of the presidency. But nonetheless, the process would be there's an assertion of the privilege by the privilege holder. So please get a court order. And then when there's a determination that the privilege doesn't exist, we are happy to tell you about all of our communications. Now, the January 6th committee didn't have the luxury of the time to be able to go and pursue it the same way the federal prosecutors can through their grand jury process. So the January 6th committee had to accept the objections on executive privilege grounds, but get all the other information that they can. So the fact that we have Patrick Philbin and Pat Cipollone, the top White House lawyers for Trump, Mark Short and Greg Jacobs, the top staffers for former Vice President Pence, all of them for the first time now telling anyone here, the Department of Justice though, and now Jack Smith, about their direct communications with Trump, what Trump said. I can't emphasize enough just what a blockbuster ruling it is for the federal judge, the right ruling to make that, and for the Department of Justice and Jack Smith to get that information. And if you're just wondering what the standard was to overcome executive privilege, well, there's probably a few arguments that are made. The first argument is that Trump can't assert executive privilege as a former president. Executive privilege lies with the current administration, which has not asserted executive privilege. But the next argument that the Department of Justice undoubtedly argued, even if you could assert executive privilege, which we don't concede that you can, where there is a compelling interest by the Department of Justice that overrides the executive privilege claim, right? The privilege being asserted is not absolute. And where there is a compelling need, you get it. And obviously, there's a compelling need to get information relating to a criminal investigation relating to the January 6th insurrection and efforts to topple our democracy by Donald Trump. And so what else does this tell us? It shows us how aggressively Jack Smith is also moving. Literally, we learn that the judge makes the ruling rejecting Trump's executive privilege on Thursday. Boom, Friday, we got Cipollone and Philbin testifying. The next day, you don't get more aggressive than that. And the fact that all of this testimony is being received now. Remember, last week, Stephen Miller testified as well before the criminal grand jury. And one of the things we talked about here on the MeidasTouch Network is that was indicative of the fact that the executive privilege assertions were being defeated, because Stephen Miller would probably have tried to assert the same thing. So in a very short period of time, right, within like 5 to 7 days, we get Stephen Miller testifying, we get Cipollone and Philbin all testifying about their communications with Donald Trump. So what's next? Former Vice President Pence. And now, because the Department of Justice has built this case methodically, because they didn't rush to an indictment, and by the way, I would have liked this to happen sooner, but all of these things take time. But because it was methodical, Pence doesn't really have an argument about why he wouldn't provide information to the grand jury. Right? I mean, the executive privilege claims were defeated. He can't assert that when his top officials already testified. Now, Pence is wondering, I'm sure, Well, what did Mark Short say? What did Greg Jacobs say? They were in the rooms with me when Trump was saying this. Like, I can't, do the normal Pence. I'm a Christian first, and then I'm a conservative, and then I'm a Republican. And so if somebody threatened to kill me, as long as they were one of those three things, I would definitely want to make sure that they are leading this country. You're not going to be able to do that crap before a grand jury, and you're not going to be able to be your phony self and lie where the grand jury now has built the information from your deputies, and you will be risking perjury if you try to lie. So I've been saying this for a long time now collectively about like all this stuff takes time. And it's unfortunate that it takes time, but it's just the reality. Like, to impanel a grand jury takes time. The grand jury doesn't meet every day. A grand jury, by the way, is selected the same way juries are selected, but they are for they're a much longer period of times than just a trial. They don't meet every day, so they sometimes meet a few times a month or on other special circumstances. But they're just, they get something in the mail that says you're summoned for jury service and you're picked as a member of the grand jury. It's very similar to the way you did jury service, except because the obligations are so long, usually it's only people who are able to do that, who are able to actually sit on grand juries, and they don't meet every day. So you have to find a day where a grand jury meets. Then you got to find a day where a witness is available, and sometimes the scheduling takes time. Then the witnesses testify. Then Trump asserts a bogus executive privilege claim. Then you have to file a motion to compel, and then the judge sets a briefing schedule, and then you file your motion. Trump files his opposition. You file your reply. The judge may have additional questions or hold oral argument. We know there was oral argument here because we've seen the videos of Trump's lawyers going into court, and Tom Windham and others who have been the day-to-day prosecutors before the grand jury also there, which tells us there was oral argument likely held with all of the lawyers there. Oral argument is held. The judge makes a ruling, and then you have to do that with every witness. And granted, when you win the first time, it creates, in essence, a precedent. Judge Beryl Howell will say, well, my ruling there is pretty much binding on my ruling here. It's always going to be a compelling interest to override executive privilege, but that doesn't prevent Trump from still asserting executive privilege each time that the Department of Justice has to fight each time. And so I'd love for that process to move quicker, but that just is what the process is. And they've been doing this now for 18 months, frankly, going as fast as they could go, while making sure that they're prosecuting all the other insurrectionists. So this has been a devastating week for Donald Trump, right? He lost before the 11th Circuit Court of Appeals. Judge Eileen Cannon has no jurisdiction. His tax returns were turned over to the House Ways and Means Committee. Now Cipollone and Philbin have testified before the grand jury on these issues now that executive privilege has been removed from the equation. And previously, Mark Short and Greg Jacobs, Pence's top people, they've testified as well. So the wheels of justice move in the right direction, folks. I'm Ben Meiselas from the MeidasTouch Network. Hey, hit the subscribe button right now. We are on our way to 1 million subscribers thanks to your incredible support. So please hit the subscribe button. And in addition, consider becoming a patron of the MeidasTouch Network. Go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's lots of exclusive perks and memberships you could only get at Patreon with exclusive content. But most importantly, we're not funded by any outside investors at all. So please help grow this independent media platform together, if you can, by going to patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.